Welcome back, everyone, to another episode of the SERMAPod. This is the podcast for the Sports and Entertainment Risk Management Alliance. I am the CEO and founder, Rich Lenkov. And as we enter the last few days of 2025, we are well over our 100th episode. So please continue to follow us and like us on YouTube and all social media. Check out our 100th episode. That is a compilation of some of the best moments from our first, can't believe it's been 5 years, or 5 years, covering all of the most relevant cutting edge topics in sports and entertainment risk, claims, and legal issues. And to that end, we are discussing today with Professor Kevin Green, the John J. Schumacher Chair and Professor of Law at Southwestern Law School. This very interesting issue dealing with fair use. We've covered fair use before, but the allegation here, Professor, is that the Rock and Roll Hall of Fame, located in Cleveland, Ohio, and this lawsuit was brought in federal court in the Northern District of Ohio. The allegation by this photographer was that his intellectual property, particularly two photographs that he took of the band Van Halen, and in particular their lead singer, Eddie Van Halen, was misappropriated, was used without his permission, without his license by the Rock and Roll Hall of Fame. The Rock and Roll Hall of Fame alleged that they were entitled to use it under the fair use doctrine. So we're here today to discuss that. That's a really long introduction. Welcome to the SERMAPod.
Thank you, Rich. Good to be here.
We're very privileged to have you. Let's walk through, first of all, what you know about these allegations. Again, this was a photographer who has brought something like 60 cases in the past alleging copyright violations of various photographs that he's used. He's a very well-known photojournalist over the years, has taken many photographs of prominent rock stars, including, in this case, Van Halen. Let's let you pick it up from there.
Sure. Well, one thing I think we should highlight at the beginning is, and I tell my students this because I teach copyright law and I teach entertainment law, is of everybody who's likely to sue you for copyright infringement, photographers have to be probably at the top of the list. I think there's no question about that. So,
Why is that?
well, first of all, we live in a visual world and a world of, digital images. And there's lots of use of those images in various contexts, social media, news articles, personal stuff that people do. And photographers, for whatever reason, feel very strongly that every use of their work should be compensated. And generally, I'm all for fair compensation, but as you indicated, there not all copying is copyright infringement, and one exception to that is if it's fair use. So I've found myself in a number of disputes against photographers. I have nothing against them, but a lot of times I found their positions to be unreasonable. And, it's just a continuing thing where images are embroiled in lawsuits. If you don't mind, I'll give you an example of one I thought
Please.
fairly outrageous. This is a photographer, and I was contacted by this group, which is a Buddhist organization, a nonprofit Buddhist organization. What they had done is they had used a picture of their temple associated with their strand of Buddhism on their website. And the photographer was taking the position that it was infringement and they needed to pay licensing fees. And I ended up speaking with him. This is years ago. And I said, really, do you realize how bad this looks? I mean, this is a nonprofit Buddhist organization. It's total non-commercial use. And it just looks like a shakedown. And ultimately, that attorney backed off of that because they didn't like the optics of it, right? I think we shouldn't sue nuns, we shouldn't sue orphans, and we shouldn't sue Buddhists, right? It's like probably put them in that category.
Good rule of thumb for everyone listening, all our viewers: don't sue Buddhists. Good takeaway. You mentioned a couple of things that I want to touch on. So, this court, I mean, this case really relied heavily on, or turned heavily on, this issue of transformation, right? The allegation or the answer by the defense, in this case, the Rock and Roll Hall of Fame, was that the use of this photo was transformative. What does that mean, and why is that so important in fair use cases, and why did the court in this case rule that that was such an important factor in this lawsuit?
Sure. So the grandmother or grandfather of the fair use doctrine in the United States is a case back in the 90s involving the rap group Two Live Crew and their use of a song by the artist Pretty Woman. And of course, it's the
Roy
music publisher
Orbison.
who owns those rights. Yeah, Roy Orbison and Pretty Woman. And that's where we got this notion in the fair use jurisprudence that one of the most important things that we look at in the first factor of fair use, which looks at the purpose of the defendant's use, is whether the defendant's use adds new meaning or message to the work that they're appropriating. And so that has stood the test of time since the 1990s. We got a kind of refresh in it more recently in the Warhol case, which I'm sure you're familiar with. And in that case, it was involving the photograph of Prince that first appeared in Vanity Fair, and was first taken by the photographer and then was used in the Vanity Fair magazine article. And the question was that use? And there was some slight differences, right, in the image that was displayed in the magazine vis-a-vis the original. And the Supreme Court, I think, basically confused everybody, quite honestly, Rich. And I think we're still trying to process Warhol, but the gist of Warhol is that they said, yes, we look at whether the use is transformative, but you also have to look if the defendant is using the image in the same way that the plaintiff was using it. And so that was the issue in Warhol. I'm sure the plaintiff in this case probably had Warhol in mind when they bought their lawsuit, thinking that that was the case. But the court really, in the Hall of Fame, Rock and Roll Hall of Fame case, leaned heavily on whether or not the images were used by the museum added new meaning or message to the original photo. They found that it did because the photographer said that he took the photo, one of the two images, to make the band, the Van Halen group, these handsome, fun-loving guys. He said that was his purpose. That's not the purpose of what the museum is doing. The museum is using it in a connection with the exhibit of the guitars to add context to that exhibit. So I feel like that in that respect, it was the right call by this court to look at it that way. The fact that it was commercial, which is one of the other factors, is the work being used in a commercial or non-commercial way by the defendant. The museum does charge admission, but if we use that rule, then you could never do a documentary because I'm going to use your image about your podcast in my doc. Now I have to go to you to get permission? I shouldn't have to, even though the documentary ultimately is monetized. I think that was a very important point of this case as well. Um,
Let's go into that in a little more detail because, as you mentioned, the Rock and Roll Hall of Fame charges admission. It's a $35 admission fee. They did not, however, charge admission for this particular display, the one where the Eddie Van Halen and Van Halen photographs were used. They are a non-for-profit organization, but ultimately, that you can't get in to see this piece of IP without paying.
correct.
So, how
Yes.
did the court deal with that dichotomy?
I mean, I don't think that in the opinion they don't go too deep into that, but I think the overarching point is that sometimes things are monetized, but they can still be fair use. Documentaries are a perfect example of that. Many documentaries are wildly successful, make lots of money. But if they really are within the zone of the first factor, which is looking at transformative use and adding new message and meaning, the fact that it's newspapers make money, media makes money, but that doesn't mean that their use isn't fair in a particular context.
All right. What about the length? Another factor is the length of the IP. How do the courts deal with that? Because they use a portion of, I think, the upper torso of Eddie Van Halen in one of the photos. Why is that an important factor? The amount of IP used, and how did the court look at that in this case?
Sure. So my experience, that factor of how much was used isn't usually the most dispositive factor. And going back to a case involving Gerald Ford's book, the Nation case against the magazine The Nation, they said that he was allowed the magazine was allowed to use more of the excerpts from the book because that's the only way that they could really put everything in context for here, they did use the photo. I think the photo was cropped. I think they cropped it, according to
Yes.
the case, and they took out some of the band members, but they did use mainly the whole photo. And the general rule is that you can use as much as you need to make your point under factor one. And so they had to use more here than but if you take too much, you can't take the whole book if you're looking at someone's memoir, but you could take enough in order to make your point, your transformative point under factor one.
Yeah, and there's
Having
no
said
bright
all this, Rich, these factors are not mechanical.
right.
They are indeterminate, case by case. And so I deal with artists all the time, particularly on the music side, but also film and television. And they have a very different conception of fair use than what lawyers do. Because as the lawyer, we realize that no fair use case is going to be a slam dunk, in 90% of the cases.
Absolutely. I was going to say that there's no, one takeaway is there's no bright line test. It's not math. It's not like you could say, I'm going to stop using this piece of music 3 seconds in, 10 seconds in. It really depends on a case by case basis. That's a difficult thing for some people to hear, but it really depends on the specifics of the case. In some cases, courts have ruled that a long portion of music or a poster or a photo is fair use.
This is a
The
dirty
last,
secret of fair use, though, because as the lawyer representing independent filmmakers or a lawyer representing, music artists, upcoming music artists, the client will be asking, "Can I use this clip of music? Can I use this sample?" And the answer is generally going to be from the lawyer in that position, I wouldn't do it. And the reason why is you might be right that it's fair use, but the only way anyone will ever know something is fair use is to go before a district court in a federal
yes.
court and have that judge decide it. Meanwhile, what's the status of your movie project while this is ongoing? It's toxic because it's in
And
litigation. So
And
the
guess how
sad
much that's gonna cost? Guess how much that's going to
and
cost
the
to get to
cost
right? Entertainment
astronomical.
lawyers don't work for free, as we know, as you know.
I don't know how much time and money you have saved to litigate against Warner Brothers, but I'm looking at my watch. I'm guessing about 2 hours, and I'm done. And meanwhile,
Exactly.
I mean, they have all the resources in the world. So there's this asymmetrical notion to it as well, where the small creator most of the time will actually not utilize the fair use doctrine for the reasons that you said, the expense of it,
Right.
the uncertainty of it, et cetera.
And, to that point, and I wanna get to the 4th factor, which is, the effect on the original, works market, but to your point, interestingly enough, we at SERMA, we do a lot of these discussions. We have our 3rd annual filmmakers and screenwriters forum coming up at the Sundance Film Festival in January. And this is a, event where we have a panel of professionals giving advice on young filmmakers, screenwriters. And one of the things, and we
You
do
should
it in
invite
conjunction.
me. I'll talk
You
to them.
should listen. You're welcome. I want to talk to you about that separately.
Yeah.
We do it in conjunction with Tish, NYU, some incredible professionals. But one thing we talk about is, you know, have the best insurance you can. Like when you're budgeting for these projects, documentaries, like songs, you better budget for legal. You better budget. You better have a fair use. You better have someone sign off on fair use because, to your point, you might be right in asserting fair use, but when you get sued, and you're going to get sued at some point, you better have great insurance. You better have budget for legal because this stuff is incredibly expensive. So you'll hear more of that at
You're
our
absolutely
event.
right, Rich. Unfortunately, in LA, most independent filmmakers don't have that. And the reason
Yes.
is cost.
It's expensive. It's
Yeah.
prohibitively
Yeah.
expensive. No, and no one thinks about it. When you're having fun making an indie, who wants to think about these legal issues and fair use? You don't even know what fair use is, right? So it's really important to consider that. What about how did this court in the Northern District of Ohio, with this Niels Lozauer, he's the name of the photographer, how did they look at the effect of the original works market? Because that's an important factor, right? If the allegation is that you can't make money off of your IP anymore because it was taken by someone else, then that's a factor. On the other hand, many courts rule that the value of your, you know, previously relatively unknown IP is heightened because someone is. How many times have we seen, artists whose work is sampled and they suddenly are way more successful because of the notoriety that they're getting when they were previously relatively unknown? So,
100%. 100%. Yes. And I thought about that too. So the last factor looks at how is this going to impact the market? That also includes potential secondary markets that you haven't gotten into yet
right.
for it. I don't know how much that would be relevant in this particular. I'm trying to think about that in this particular area with the photograph. Um, the courts in that factor, it used to be a really important factor, by the way. I always taught my students before Warhol and those related line of cases that number one is transformative use. Most important thing they would look at would be the effect on the market. Here, they kind of poo-pawed that, and I'm not exactly sure if I agree with the reasoning because, I'm probably like you, and I shouldn't make this assumption, but I'm for the underdog in the entertainment industry. I'm for the small people because I think that's where the great creativity comes from in film and television and music and the like. And in this case, he couldn't really show much market use of the photo.
Right.
In fact, I think one of the photos hadn't even been published, if I recall the court decision. And so they seemed to nick him a little bit on that to say that this would actually hurt his sales. But I'm with you that it could be the opposite. Now, and this is how I would look at it, maybe if I was advising him, is look, your your work is in the rock and roll hall of fame. That is huge. You can market that, you can tout that, I think that's a big flex to be able to do it. So maybe you, as you're suggesting, you'll make more money from this use because you can use this in your marketing and your advertising materials. Look at me, I'm in the
Exactly.
Rock and Roll Hall of Fame.
Right. Exactly. And a lot of these artists, again, no one probably knew a lot of this work before they filed suit and got a lot of notoriety from it. So that's an argument frequently raised by defendants. Professor Kevin Green from Southwestern Law School, really appreciate you being on. In addition to your esteemed academic career, you've got incredible career in this field. You have represented artists like Harry Connick Jr., Bobby Brown, Public Enemy, who has a lot of gave you a lot of work in this area for sure, and also Spike Lee's 40 Acres and a Mule Company. So really
And
appreciate you
George
being
Clinton,
on. And George Clinton, legendary
King of
P-Funk
Funk.
lead singer. That's absolutely true. Really appreciate you being on. Please come back and join us on the future on this and other issues. And hopefully we'll see you in Sundance. We'll talk separately about that.
Thank you, Rich.
Thanks so much.